so sorry.
Appeal in the matter of Zedra Trust Company Limited and the Hut Group Limited and others.
Good morning, my Lord.
Good morning.
My Lord, may I deal with some housekeeping matters to begin with?
Yes.
Firstly, my Lord, the question of mobile phones. We seek the permission of the court to be able to access our mobile phones because there are various WhatsApp groups going on with my clients in Manchester and I think the other side of the
So long as they're on silent.
my Lord. They will be on silent. Secondly, my Lord, I hope that yesterday you received 2 additional authorities by email.
Yes.
And we have
One of them I probably didn't need.
My Lord may not have needed, but
Yep.
and they're inserted at the back of the hard copy bundles at tabs 31 and 32.
Yes.
My Lord, I've also handed up, and I had my clerks email, a copy of the table of directors, which sets out the current position of the individual respondents and whether or not they are still directors. You'll see a number of them resigned on the 26th of August 2020, and that is because the company went through a public listing, and that's an important matter we'll come on to in a moment. My Lords, this appeal concerns the unfair prejudice petition brought by Zedra Trust Company.
Mr. Ashworth, before you just launch yourself, have you agreed with Mr. Chasty the timing of your submissions?
My Lord, yes. I've agreed with him subject of course, and the court has to say that I will take until 3 o'clock today. He'll then have the rest of today and most of tomorrow morning with a short reply from me from 12:30 tomorrow.
Perfect. Thank you.
So is there anything else, my Lord?
No, that's what I wanted to hear. We'll not take a break mid-morning, but I think we are being provided with a transcript, are we?
I wasn't aware of that, my Lord. Oh, yes, we are. Thank you, yes.
Thank you.
So, my Lord, this is the appeal concerning the unfair prejudice petition brought by Zedra Trust Company, Jersey Limited, a professional trustee, in respect of its shareholding in THG PLC, which is now a publicly listed company with a market capitalisation of approaching £6 billion. My Lord, there has been a change of name of the company since the petition was presented. It was then the Hut Group Limited. It is now THG PLC, and there will, I suppose, in due course be an application to amend the petition if it survives. My Lord, we say that on a proper analysis, neither Zedra's complaints nor the extraordinary and novel relief that it seeks come within the statutory unfair prejudice jurisdiction. His Honour Judge Eyre correctly observed in paragraph 24 of his judgment that neither the unfair prejudice jurisdiction nor the potential range of relief is limitless. And we all know, as Lord Hoffman said in O'Neill and Phillips, the exercise of the unfair prejudice jurisdiction must be based on rational principles, and while the court's discretion is wide, it does not sit under a palm tree. My Lord, we say that this appeal provides an important opportunity for the court to restate the principles that govern the unfair prejudice jurisdiction and mark the outer limits of relief that can be granted under it. The principal relief that Zedra seeks is an order requiring THG to issue shares to Zedra in such amount as remove the dilution caused to Zedra's shareholding in the company since the 18th of February 2016, and to restore Zedra's shareholding in percentage terms to the level of its shareholding as at the 18th of December 2016. Alternatively, such later date of the court orders. And that is paragraph 6 of the prayer at page 116 of the core bundle. My Lords, it is not relief that certain shareholders transfer their shares to it. It is a relief seeking the issuing of new shares, contrary to the suggestion in Zedra's skeleton argument at paragraph 42.4.
But the court could order that as an alternative. It could say to Zedra, well, we accept you have a good case, but we think the appropriate order is not an issue of new shares, but a transfer of shares by persons responsible for the unfairly prejudicial conduct.
My Lord, we say no, that goes too far. There are various other remedies that the court...
Why couldn't the court? Are you saying it would be beyond the jurisdiction of the court to do that?
My Lord, that would be confiscating property. In the
Well,
same
no,
way.
it would be saying you, the wrongdoers, because I said that these were the persons responsible for the unfairly prejudicial conduct. If that was established, you, the wrongdoers, must compensate Zedra for your wrongdoing by restoring its percentage shareholding by transferring shares.
Well, or that depends, of course, whether they have enough shares to do that.
Well, of course, if they don't, then the court can't order it.
And of course, here the shareholders.
But supposing they do have enough shares.
Well, my lord, I'd say that the proper remedy would be for the court to order compensation.
Well, that'd be a matter for the court. But are you saying that the court couldn't order the wrongdoers to transfer shares so as to restore the relative size of Zedra's shareholding?
I'm saying as a matter of reality, it couldn't.
Why?
On this
Why
case.
couldn't it?
Because the respondent, in the respondent's name, don't have sufficient shares.
Well, there's nothing to tell us that at the moment.
Sufficient for what?
To restore to their shareholder. So,
Well, I mean, we don't know yet until the facts are found, who's responsible and how many shares they have and what the remedy would be. I mean, my lord is asking you about whether there is jurisdiction. And surely you'd have to accept there was jurisdiction to order a wrongdoer, I'm using that term loosely, to remedy the wrong by transferring shares or paying money or doing anything else.
well, certainly by paying money, my lord, by transferring shares might be an issue, but certainly a remedy could be fashioned. That if
I don't understand why you say that there wouldn't be jurisdiction under Section 996 to make that order, or why you say, well, even if theoretically it exists, as a matter of practice, it would never be ordered. I don't really understand why you say that.
in the case of a wrongdoer, my lord.
Yes.
As opposed to
Yes, those, let us assume, this is all just assumption, but you are actually, your challenge is on the basis of whatever is established at trial, the court can't give this type of relief. So let's just assume, that it was established at trial that 6 of the directors were responsible for unfairly prejudicial conduct resulting in a dilution of Zedra's shares. Now, why couldn't the court, either as a matter of theoretical jurisdiction or practical jurisdiction as to what it was prepared to do, order the wrongdoers to transfer shares, either to make up the deficiency, as it were, or to go some way towards doing so?
Well, my lord, it probably could. I think the court could do that, my lord,
Yes.
providing it's targeted at
The
particular wrongdoers.
Yeah, I follow that. I follow that. But and then you say, well, that's not actually what is asked for in the petition. But I mean that seems to me easily curable. And in any event, it might, at the end of the trial, the judge might say, well, I'm not prepared to order an issue of new shares, but I am prepared to order a transfer of shares. Zedra, do you want it or don't you?
Well, my lord, that's conceivable if they could get the rest of the claim.
Oh, of course,
Yes.
of course. That's a different issue.
But what we have attacked this petition because the relief that is being sought
Well, I know.
is a relief which we say can't be granted.
All right.
Because the issuing of shares is not directed at the wrongdoers, the alleged wrongdoers.
Well, let's take another way of doing it. Supposing that the court thought that the proper way of compensating the Zedra was to provide it with further shares, but it's rightly said on behalf of the company and, as it were, all the other shareholders. Well, that's going to dilute the other shareholders unfairly. Why could the court not order the wrongdoers to pay to the company sufficient funds to procure the issue of shares to Zedra? And by paying sufficient funds, I mean paying a proper price for the shares, not just par, but whatever was a proper issue price.
My lord,
Because then there wouldn't be any unfair dilution of the other shareholders there, because the company would have received full value for the shares.
we say, well, that's something which should never happen, because why do you need to go further than ordering those wrongdoers to compensate Zedra directly, where you've got a publicly listed company?
Because it can go in the market
just
and
go in
buy the
and buy
shares.
them.
All right. Okay. Well, that may be. I mean, it might depend on the circumstances. I mean, not Zedra. THG might not be listed at that point.
Yes.
So it all depends on the circumstances at the time, doesn't it? Whether the court comes to decide on the proper relief.
My Lord, of course it does at the time. We're saying the relief they're seeking is the relief that could never be granted. The relief your Lordship postulates is relief which would never, as a matter of practice, be granted when you've got a listed company, where you could just say, right, you 4 directors have been guilty of wrongdoing here. That's called Zedra a loss. And we'll come on to examine whether that's possible. That's called Zedra a loss. You must pay to Zedra, it would be 235 million is what they're after as far as we work out here. They can then decide whether or not they go into the market to buy the shares or not. But
yes, but I mean, the last 2 minutes is the first time I knew, for sure at any rate, that the shares in this company were listed. When this petition was issued, the shares were not listed. As far as I know, when it was heard by the judge below, the shares were not listed.
they weren't.
You're introducing, in support of your appeal, a new fact, which you've not actually, it's not even in evidence, but I mean, I'm sure we accept what you say, that the shares are listed. But this is a new and unheralded ground for your appeal, isn't it?
Well, it's not a new unheralded ground for my appeal, my Lord. It's a response to your Lordship's suggestion of an alternative route forward.
But Mr Ashworth,